Tina Peters might be able to get out of prison earlier than expected without a make-believe presidential pardon or a military rescue mission or any of the other unconventional ideas her defense team has floated. Because today, judges on the Colorado Court of Appeals expressed concern that Peters' 9-year sentence did not follow the law. Marshall Zellinger and I were in the courtroom today, and I mean, Marshall, this started out pretty rough for Tina Peters' legal team. I mean, the judges were essentially laughing off this idea that she had federal immunity for what she did or that the state didn't have jurisdiction. But then the focus turned to the sentence, and the judges had some real concerns.
Sure, right. The main argument that her attorneys were making is that she had federal immunity for what she did as a county clerk, and that was clearly not impressive to the judges. But what they questioned the state about could get Peters out of prison early or altogether. One judge said he was baffled that the state would not budge on what appears to be a sentencing error, and the appeals court questioned if the judge that sentenced Peters gave her a harsher sentence strictly because she ranted about election rigging.
He can't sentence her more because he doesn't agree with what she's saying.
And with that brief sentence, it became clear the Court of Appeals judges seemed willing to agree with Tina Peters' attorneys that she may have been over-sentenced. She's serving more than 8 years in prison for her role in allowing unauthorized access to her county's election voting equipment when the state came in to do a trusted build refresh before the next election. While she was prevented from bringing election rigging conspiracies into her defense, the appeals judges wondered aloud if the Mesa County judge who sentenced her used election rigging conspiracy rants to give her a harsher sentence.
And you're a charlatan who used and is still using your prior position in office to peddle a snake oil that's been proven to be junk time and time again.
Why should we not be concerned that he focused so much on her continued peddling of the snake oil?
I mean, I'm not saying you shouldn't be concerned, but I don't think there's an error.
There was a moment when it seemed the judges felt Peters' sentence was at least 15 months too long. They pointed out that in one of the counts, the jurors may have convicted Peters of a felony instead of a misdemeanor because of an error in the charge's description.
I'm confused as to why the people are continuing to maintain that the proper remedy on this isn't to enter the conviction for the misdemeanor.
It was one word, might, and it was already...
Yeah, but that one word distinguishes it from a felony to a misdemeanor.
And in this case, made an extra sentence, 15 more months in the Department of Corrections that couldn't have been given had it been a misdemeanor conviction. It clearly affects a substantial right.
The attorneys for the state took the position that the felony conviction and the 15-month sentence that went with it should stand.
I understand it's a difficult position for the people to be in. But
it's not a position you have to take.
After the hearing, Peters' attorney, John Case, said that resentencing Peters is not satisfactory, that the conviction should still be tossed, and if she is resentenced, he hopes it would be time served.
The fascinating thing, Marshall, is that all of this may just get us back to the point where we were until the moment of her sentencing, when we expected that here we are, right? She's this older woman. She doesn't have a previous criminal conviction. Sure, she shows no remorse, but what's she likely to get? I don't know, probation, a year or two. Then she gets up there, she lambastes the judge for 45 minutes, and we're like, holy heck, now the meter's running. She's got 9 years. And today the judges said if that judge ran the meter because of her speech in the courtroom, that's a problem.
But one of the appeals court judges did say the sentence was within the range that is allowed. I believe he was referencing that it seems harsh, but it is still within the allowable limit. I'll note earlier this week we talked about when is her earliest parole eligibility date. The official date, if all goes well and nothing were to change, March 2nd, 2028. But if you knock 15 months off the sentence, just at minimum, we're getting pretty close to that date.
It will be fascinating to see. Her attorney says that simply resentencing her is not sufficient. Will that be sufficient for a President Trump, a Governor Polis, for all of her other supporters if it takes months and months and months for this to play out? Really interesting day in court. Marshall, thank you.